Hence, all the matters stands adjourned as a last chance. Next, it is provided that on the next date, the prayer for adjournment shall not be entertained. Just after 4 weeks.
Lordship, another prayer is for listing of a petition. Pending matter, Lordship. Next week, any date, 19.5, Lordship.
What is the matter?
A non-payment of yes.
Non-payment of salary. Okay. Okay.
No, replacement.
Daily list item number 1, motion BA.
May it please, your Lordship.
Yes.
My lord, earlier rejected by Lordship. Allegation under the NDPS Act. So 141 days in custody, my lord. Last application was rejected in the month of January.
Yes.
Lordship, in my humble opinion, this is a premature application. Earlier it was rejected, and today 140 days is completed. The investigation is going on, Lordship. And commercial quantity of Lordship 3 materials: ganja 153 kg, then methamphetamine tablet and heroin, Lordship, along with one pistol, Lordship. And mandatory period is 180 days, Lordship. And I don't find any fresh reason.
Yes, Mr. Hazarika, what do you say?
My lord, here, although sections are, my lord, serious in nature, but my lord, my highest right under the constitution, my lord, is at stake. Last time I approached your lordship, that is 3 months back. Now, my lord, that is my new ground, my lord. Every day, my lord, my right to freedom, right to liberty is at stake. And my lord, I have my own defense, my lord, because I was not arrested with the main accused, my lord. So at this stage, your honor, your lordship may call for a status report whether my detention is required, because I am not in the same footing.
Okay, that is that information.
Lordship.
When? Give a date, Mr. Kyal.
After a week, Lordship.
Give a date. We'll fix it on that day.
Lordship,
Avoid Tuesdays and Thursdays.
Lordship. 26, Lordship.
Okay. That the status report of investigation in respect of the petitioner be produced on 26/5/2023.
Yes. I am deeply obliged, my lord.
First.
Hearing item number 3.
Lordship, in this case, I am going to file affidavit today itself, Lordship.
We can't permit that.
Lordship, I am
2017, if you wake up every day,
today itself, Lordship, one day, Lordship. I have
we can't permit you to wake up at the time of hearing.
Lordship, already we have filed, we need to file additional affidavit, Lordship.
But
As per direction of the Honorable Court, Lordship. One affidavit has been filed, Lordship. As per direction of the Honorable Court, we need to file additional affidavit, Lordship. That
When was the direction issued?
14/9/2020.
Huh?
Direction
14/9/2020.
14/9/2020.
Yes, my lord.
Then Mrs. Bora, some cost.
Lordship, because a matter has not listed when we pursued, but due to some
No, we understand.
technical problem, Lordship.
We understand. But every technical problem can be solved with money.
Lordship, kindly Lordship one day, Lordship. I tell myself, I've already prepared Lordship.
But where is the order? Which order you said?
Lordship, on 22/3/22, Lordship. Because as per petitioner saying that petitioner is working Lordship, that instruction Lordship. As per our instruction Lordship, after termination, managing committee allowing him to do
No, my lord, no
Lordship.
termination order was issued.
Termination order is also, I am annexing Lordship, as a whole termination was done in the year 12 November 2004 Lordship. As a whole Lordship, all mother teacher, LP English teacher, LDA, ME, and Lordship Malis of high schools, assistant teachers in high schools and councils.
And counsel for the petitioner is present. By referring to order dated 22/3/2022, this is R.B. Boral and its standing counsel for BTC. Submit that the BTC authorities will be filing an affidavit in course of day to day. It is noted with concern that the court query was put on 22/3/2023. And after about 14 months, the BTC authorities have woken up to file their affidavit as if they take it for granted that the court would permit such an affidavit to be brought on record. First off, it is made clear that since the matter is being adjourned at the request of the prayer made by BTC, the authorities will take, the BTC authorities will take note that if affidavit in additional affidavit as directed by order dated 22/3/2022 is not filed within 10/5/2023, the respondents in the BTC shall jointly and severally pay to the petitioner. It shall take notice as to why this court should not impose a cost of rupees 50,000 on the BTC for not filing their affidavit in additional affidavit as directed by order dated 22/3/2022. Next para list on fixing it next week.
Maybe 16, my lord.
Make it 15. This is 16. I have
15, I am
very-
not available, my
then
lord.
17 because I
17.
have some parted matters fixed
Okay.
all these days.
17.
17/5/2023.
Deeply obliged,
So
Lordship.
if you're not filing within tomorrow,
Lordship.
it is the last one 50,000 cost.
Lordship. I shall file. Deeply obliged.
Yes, item 4.
4 and 5.
Kindly pass over for the time being. R. Mujumdar will appear in the matter. He is on leg, my lord. Put number 16, my lord.
Okay. Mr. Chaudhary, you are for the petition.
In this first of the two cases, I am for the private respondent. In the second writ petition, I am for the petitioner.
Okay.
And the petitioner.
Can
counsel
we,
is not there.
Mr. Sharma?
Yes.
We'll start hearing Mr. Chaudhary so that
Yes.
we
But
spend the
counsel
time.
for the petitioner in the first petition is not there.
Yes, yes, I
And
understand.
there is no information that they'll ask.
I
for.
understand. Because this is one school, Asmia, where I find that every few days this litigation of this school is coming up.
Yes, my lord.
In
In fact,
every few days, this case, some case or other of this school is coming up.
In fact, my lord, the politics has gone into the education, my lord, the institution in such a manner. In fact, my lord, these litigations ought not to have been there at all.
No, I understand you are correct. If the education department takes up the matter, adjudicates it, everything, litigation could have been avoided.
Yes.
That's why you start.
Now, my lord, the first case has to be heard first in the sense that, my lord, a prayer in the first interpretation is that on the basis of some inquiries which were made,
Yes.
action has to be taken against the private respondent, that is my client. That is the prayer in the repetition.
Okay, I understand. You are right. So therefore, this has to be heard first.
Yes, my lord. And my lord, the reports of the inquiry based on which this petition has been filed and asked for an inquiry, those reports are challenged in my petition.
Okay.
My contention in my petition is that all these inquiries have taken place at the behest of some persons of with their oblique motive, and I have not been associated with any of the inquiries.
So you wait for some time then. You are right.
Fine.
If the allegation is against you, you'll have to make
True.
this argument process. But Mr. Bhuya is normally there. We can wait for some time.
Yes.
Mr. A.R. Bhuya appears for him.
In fact, H.R. Chaudhary appeared earlier once. Now, my lord, huh? And A.R. Bhuya also appeared.
Okay. A.R. Bhuya. Item 5, item 4.
Without going into the merits of the case, I'd like to submit before Lordship that, my lord, this petition does not now, my lord, require any adjudication because the school is no longer there.
No longer there.
It's not, it's an amalgamated.
Oh, acha. That's why
And-
perhaps what you call prayer was made on a point of maintainability.
Yes, my lord.
Okay.
That is one point. The other point is that, my lord, the president cannot represent the school. He was the president at that point of time. He cannot represent the school, and at the same time, now he is no longer the president of the managing committee.
Okay. Okay, I get it.
If your lordship accepts that argument, then perhaps your lordship need not go into the other aspects.
This
Anyway,
is
let him submit.
better. It's a good choice. Yeah.
Right.
Man.
Part two hearing list. Forty-eight and 49.
It is also submitted. It is also submitted that as per clause 4, of the appointment order dated 24/8/2016. An appointment order of the private respondent. It has been specifically mentioned that inverted commas, no provincialization order will be affected in case of schools having any court cases in connection with appointment of teachers, dispute on land, absence of dice code up to 2009 and others in conformity with the provisions of it's not there, with the provision in inverted commas start, the Assam Venture Educational Institutions within bracket provincialization of services bracket Act 2011, amendment 2012 inverted comma closed. Accordingly, comment is submitted that the appointment order could not, in respect of respondent, the private respondent could not have been made effective. So it is submitted that in any event, as the case was not referred to the district level redressal committee. This is a quick case to remand the matter back to the authorities for having the dispute between the petitioner and the private respondent resolved by the district level redressal committee in terms of order dated 12/12/2013, passed 361 of 2013. In support of the submissions, reliance is placed on the case of Akadas Ali, AKADDAS Ali versus State of Assam and others, 2014, within bracket 4 bracket close GLT 55, and Fakar FAKAR, next word Uddin UDDIN, Laskar within bracket MD bracket closed, and others versus State of Assam and others, 2016, within bracket 5 GLT 187. Next. The learned standing counsel for the Elementary Education Department has submitted that the Assam Venture Pursuant to Act 2011. Has been struck down by this court. And accordingly, a new enactment has been made by this legislature, being the Assam Education within bracket provincialization of services of teachers and reorganization of educational institutions bracket close Act 2017. So it is submitted that as per the decision of this court, in the case of Purnavati PURNA BATI Brahma versus the state of Assam and others, WA 283 of 2019, decided on 13/11/2019, comma the consideration of the issue of provincialization is to be made under the 2017 Act. Full stop. Next one, the Learned Council for the Private Respondent has submitted that till May 2011, the petitioner was working without being paid any remuneration in the school concerned, and that financial help started coming from the month of May 2011. And immediately thereafter, on 28/6/2011, the private respondent had resigned from the resigned as Anganwadi helper. So it is submitted that in both the services rendered by the petition by the private respondent, i.e. Anganwadi helper and as assistant teacher in the venture school, the private respondent was doing an honorary job, and there was no working hours in the Anganwadi center, which came in, and the working hours came into effect by virtue of notification dated 26/5/2011. So it is submitted that the said notification dated 26/5/2011, where the time was fixed, was applicable only on if the Anganwadi centers were operated in their permanent building, club building, or own premises. Hence, it is submitted that the said notification dated 26/5/2011 was not applicable in this case, as the Anganwadi center and the school were operated from the same premises. Full stop. it is submitted that this court, on an erroneous submission made by the standing counsel for the elementary education department. Had accepted. The submissions to the effect that that notification dated 3/1/2013 that by notification dated 3/1/2013, the state government has appointed district level redressal committee and state level redressal committee. And accordingly directed that the exercise be carried out by the district level redressal committee. So by referring to the provision of section 10, rule 10 within bracket 8. First, rule 10 as well as rule 10 within bracket 8 of the erstwhile Assam Venture Educational Institutions within bracket provincialization of services bracket Act 2011. It is submitted that the said discrete scrutiny committee was the appropriate authority constituted to scrutinize the service record and other related issues of the serving teachers and staff of venture educational institutions pertaining to provincialization of their service. Which was not vested with the district level redressal committee. It may be mentioned that. Next button, it may mention that. The Learned Senior Counsel for the petitioner had produced a copy of notification dated 2014, where there was a reference to a notification dated 30/1/2013. And accordingly, the order dated 25/4/2023, the Elementary Education Department was directed to produce the said notification. Stop. Accordingly, it said. Accordingly, referring to the notification dated 30 January 2013, committee submitted that the grievance redressal committee at state and district level was constituted to address the grievances with regard to the application for provincialization of the financial assistance from the government, including allotment of Dias court and change of the correction of management authority as shown in Dias records. And the same, therefore, committee submitted that the district levels redressal committee did not have the empowerment to adjudicate the interstate dispute between the petitioner and the private respondent regarding status as first assistant teacher and claim to provincialization. Hence, committee submitted that under the changed circumstances, when the 2011 Act has been repealed and the claim for provincialization must be now in terms of the 2017 Act, committee submitted that if the matter is remanded for a fresh adjudication by the district level redressal committee in terms of order dated 12/12/2013 passed in WBC 361 of 2013, it was cause the private respondent to suffer irreparable prejudice. In support of the submissions, the learned counsel, the private respondent has placed reliance on the case of Raman Kutti Guptan, RAMAN AUTTY Guptan GUPTAN versus Avara AVARA. AR 1994 SC 1699. Yes. Both sides present in any case.
58. UGC is there, only higher education is not.
SC higher education.
Lordship, K. Gogoi is on legs, Lordship, I'll inform him, Lordship, for item 54, his city is
58.
coming, yes, 58,
58.
58.
Okay, okay.
I'll inform him, Lordship.
Let him start. Additional.
No, because Mr. Gogoi would not be knowing what argument has been made. He has to respond to that. Next one. Considered. The materials available on record. The petition in WBC 1177 of 2015. Affidavit in opposition filed by respondent number 8. Reply affidavit filed by the petitioner. And in the proceedings of WBC 5209 of 2016. Consider the writ petition. Additional affidavit filed by the petitioners. Affidavit filed by respondent number 6. Reply affidavit filed by the petitioner. Affidavit in opposition filed by respondent number 9. Next one. It is observed that this court had placed reliance on the submissions made by learned standing counsel for the Education Department to the effect that the state government had appointed district level redressal committee and state level committee, and thereafter directed that the exercise to determine the dispute between the petitioner and the private respondent to be carried out by we examine by the district level redressal committee. So it would be relevant to quote the contents of order dated 12/12/2013. This will be at page 40 in WBC 1177 of 15. You there?
Oral mark. Night week.
That's where the counsel of the petitioner has gone out now. He was here, sitting here. Just find him maybe outside.
Lordship, he informed me he went to course number 8, Lordship, for some.
Okay, okay. Just wait for some time. I see. Yes.
My Lordship.
Your item was item number?
Item number 58. In this case, Lordship, petitioner has challenged the decision of the government
Just
by
wait,
which
just
the
wait,
system of
let me get the file.
Here also I have pointed out other things also, Lordship. That particular OM 2015 Lordship. After that Lordship, now 2022 OM is there. After that Lordship, 3, 4, 5 OM is Lordship coming. Now it is not in existence also, Lordship.
matter is it also
No, but insofar as this post is concerned,
Lordship. The post which was advertised, Lordship, they are already filled up, Lordship. that post.
they're already filled out.
No, it was not filled up. Advertisement was stayed, so it was not filled up. Advertisement was stayed because of this.
No, but after a lapse of what you call 7 years, you
Lordship.
can't permit that recruitment to go on with that old advertisement. That's a practical difficulty.
Lordship.
And challenges to the decision of the government of abolishing giving oral marks, which was in violation to the UGC regulation.
If that particular OMC still exists, then Lordship, something is there in the repetition.
Now what is the law?
Now, Lordship, the state government has issued OM Lordship, another OM Lordship in 2022 Lordship as per UGC's recommendations, Lordship.
No, these oral marks are there or not there?
Oral marks is not there, Lordship. Oral marks are not. 5 percent marks, 3 marks is there, Lordship.
3 marks are there.
3 marks are there, Lordship. 3 marks are there,
Because oral examination must be held.
Lordship.
I have seen, I have attended few what you call recruitment processes.
Just 20% out of 100.
এইটো এখন তো হেৰি আছিল, এখনতো follow কৰিব লাগিব।
Because even today, I am rising early to take interviews.
Lordship,
And I can tell you with my experience,
Yes.
I don't know what your case is about,
Lordship,
but my experience is that on oral examination,
Lordship.
the real assessment can be made.
Lordship. That's the main purpose for abolishing the interview marks is, Lordship, that due to favoritism, nepotism, Lordship. Meritorious students are deprived, Lordship. Even my Lord may, even some of the candidates, Lordship, who have in the Lordship, the subjective satisfaction, they have obtained, Lordship, more than Lordship. They are, Lordship, in the mark sheet, Lordship, they are even 70% and above, Lordship. The persons who have, Lordship, less than 65%, Lordship, by way of that 5 marks in the interview, Lordship, they are top.
I'm not making any comment.
No, I'm not saying that.
I'm just thinking aloud.
Just because of that, Lordship, regarding our education department, I have seen for the education department, Lordship, due to this, Lordship, that particular marks was abolished, Lordship.
It's okay. You see, I'm just posing a question to you
Lordship,
without any motive.
Lordship,
No
Lordship,
motive.
Lordship,
Just I'm trying to understand.
Lordship.
Since Mr. Samua is representing UGC, I'll put the question to him.
Lordship.
Mr. Samua, do you remember the name of the boy in your class who stood first every time from class 1 to class 10? You remember him?
Every time to, I do not remember, but
Few of them you remember.
yes, sure.
How are they in life now?
Somebody is doing well, somebody is not.
Somebody is not. So this answers your query. You see, in practical world, um, how somebody will fare, we don't know. Every students may be doing better. And maybe today, in fact, one of my friends sent me a video. A boy of Indian origin, he is 45 now. He has done his medical. He has done his engineering. And he has also obtained one more degree. And he is now selected by NASA for the space projects. He is an astronaut now. One Jichkar, I forgot the name. He's a MP from Maharashtra. He expired at a very young age. At about 55, 56, he expired. In India, he is the highest degree holder. He has got 18 professional degrees. So see, professional degree may not mean that you may be first in every time. Real assessment, I don't know whether it can be made in this manner. But Mr. Prakash, everything said and done. If the regulations have been abolished, we really don't have to adjudicate if it is only 3 marks, as Mr.
Are they saying that UGC regulation has been amended by incorporating or by abolishing the oral?
No, he says that marks are there, 3 marks are there. 3 marks is minimal.
Our contention was that it was against the violation of UGC regulation.
And at that time, perhaps my friend is correct. At that time, cause of action survived.
Cause of action-
Cause of action was there.
Yeah.
But now perhaps the cause of action has not survived.
You have this notifications on record,
My lord, that my friend will produce.
Yes.
Mr. Gogoi.
Lordship, tomorrow I can place him. Tomorrow. Otherwise, at 2 also, Lordship, I will be.
Okay, so that I can dispose it off
Yes,
since I'm taking up the hearing.
At 2, my lord, if
No,
lordship.
it's okay.
Dispense my presence.
Well, dispense your presence. No issue with that. It's at 2 o'clock then. If that is we don't have to adjudicate. Since your grievance has been redressed subsequently. You just close by recording that. Okay. Mr.
Sir, the
Chaudhary,
Lordship, T4 office memorandum is there, Lordship. The latest one, whether that marks or not, I will produce it, Lordship. All the office memorandum, Lordship.
I have filed my affidavit, it is on record.
Mr. Chaudhary, in your matter, Mr. Barwa has come.
He wanted some adjournment, right?
Lordship, unfortunately, actually, Lordship, there was some discrepancy to make list in our chamber, Lordship. So Lordship, we have left the file in this chamber, Lordship. Kindly list the matter next week.
No, that's a
Lordship, I seek
difficulty.
sincere apology for that.
That is the difficulty. Getting matters listed is a difficult task. You are for the petitioner.
Yes,
The
Lord.
first case, yes.
Yes.
Can you not do it in the second half? Because you see, if I have to adjourn, I'll have to adjourn for more than 2 weeks. I can't manage the board. Next week, 2 weeks, there are many parted matters coming up in the hearing days.
I have no difficulty at 2 o'clock.
Hmm?
In the second half, I don't have any difficulty. I can wait.
Lordship may adjourn it for 2 weeks.
Mr. Chaudhary,
Right.
just to understand your part, in the first writ petition, the prayer is to take action against you in view of the inquiry report.
Yes, my lord.
This inquiry report is at page 35.
There are
Is-
3 inquiry reports.
Or is it?
Three.
Okay,
three reports.
I did not see that. Page 35 is one of the inquiry report.
Yes, my lord.
I don't find from this report that you were heard in course
In
of
fact,
inquiry.
in all these 3 inquiry reports, my lord, I was not heard.
You were not heard.
That is my case in the other writ petition, saying that without hearing me, they have come to some certain findings. Without hearing me, they cannot take any action.
Okay. Because for me, to read alone is very difficult. So
True.
whatever
True.
I read, I don't know whether I've correctly understood or not. That's why I put you that
My
question.
lord.
So that is the only,
That is my only ground on the writ petition, and the allegations that were made also without any basis, and the findings are also not based on records. That is my case in my
okay.
writ petition.
So in fact, with that submission, I don't think any list of dates would be required. In this case, would I need a list of dates? No.
Will not be, may not be required.
Okay. Then don't do that exercise, preparing a list of dates, correct?
Lordship,
Don't do that exercise of making list of dates. Next
Lordship.
time you bring the file.
It won't-
Lordship,
It won't happen again.
we'll take care of it, Lordship.
Mr. M.K. Chaudhary, Learned, Senior Counsel for the petitioner in WBC 6185 of 2021 is present. Along with Mr.
Ikidas.
Ikidas, is instructing counsel. On behalf of the petitioner in WBC 1361 of 2019, a prayer for adjournment has been made. It may be noted that on 25/4/2023, the matter was adjourned on the prayer made by the learned counsel for the petitioner in WBC 1361 of 2019. As adjournment was sought to make submissions on preliminary point of maintainability. Full stop. Therefore, the prayer for adjournment is not appreciated. Full stop. It is made clear that apart from the preliminary issue, if any, the matter would also be heard on merit on the next date without full stop. Just for hearing on, give a date, fixed date. After
29/5.
it's a Monday.
So Monday, my lord, no problem.
We will take it up. Yes, don't worry. You just make a mention, even if it is down below in the list, just make a mention. We'll take it up. In the morning at 10:30, please make a mention that I take up the matter.
15/5.
Well, so far as this hearing items, item 51 and 52, I'll do it in the second half, my lord, if your lordship permits.
Definitely, no issue with
And
that.
item number 56, my junior colleague will argue now, my lord. 56. I'm like.
Deeply obliged, Lordship.
Part 2 hearing list 55. 56 and 57.
So Bhattakur is there, no. The difficulty in part 2 is that nobody is, both sides are not there, very difficult to take up. Item 55, part 2, says Bhattakur.
As for Thakur, your lordship might be for the respondent number 5, who was newly impleted.
I don't know, here it says respond who.
It ideally should be, your lordship, the Central Government Council. Initially, my learned senior, Mr. N.C. Das sir, was conducting the matter on behalf of Tezpur University. Thereafter, the briefs were handed over to the Central Government Councils. This matter had come up before. Your lordship had directed them to appear on the next call, your lordship.
But then please inform the CAC who appeared on the last occasion.
Kostov Gogoi appeared, but he said that he will intimate the concerned council accordingly.
In this case, CSK Bora will be appeared, Lordship. His name is also reflected in the cause list, Lordship. I have informed him, Lordship.
Okay. Okay, we'll take it after some time.
Lordship.
58,
58, this was the last matter. 58, at 2.
59,
Don't call nobody is there.
Even 59, no one is there.
Here again, the same problem, Mr. NLV Chaudhary is not there. You have instructions in the matter?
Not at the moment, I don't have any instruction.
So if both sides are present, please call me, I'll come back.
অন্য আপোনালোকে এটা 51, 52 আৰু 58 এই দুটা ফাইল লাগব 2টা বজাত লগাম এইটো মই ওপৰত দিছো 2টা বজাত আৰু 51 52 এইটো ওপৰতে আছে নেকি তোমাৰ মেইন ফাইল নালাগে এইটো এইটো কিমান বেছ হৈ গৈছে 48 49 এইটো অৰ্ডাৰ চিট আহিব লগাই থব লাগে 51 52 মোক দিলা মই বাকি এই দুটা হলে হ'ব 56 57 টো অলপমান বেলেগকে থৈ দিয়াচোন মই এটা দিছিলো তোমাক এই সাইড ক্লিক কৰিব পিছত মাজত লাগিছে হয় না এইটো 56 57 পিছ নম্বৰটো আছে 2561 হয় নেকি 2561 ঠিক আছে এই তিনটা কেছ হৈ গৈছে
That I have already left. Oh, your lordship, on coming to know about that notice, your lordship, I came back. I don't even have to file today. On Tuesday next, if your lordship called it, I can prepare myself.
Okay.
Lordship. Deeply obliged. Lordship.
$51 and $62.
This matter I'm led by my senior, Mr. Abdul my lord, he's right outside, if I may allow to. Okay, he's on his way. Yes. The list of dates for both the matters.
Can any other matter be taken up, Mr. Prakash? Your other side is here.
Lordship.
You're supposed to submit a notification.
Okay. Can be taken up.
Lordship.
Oh, yes, Mr. Chaudhary is come.
I'm sorry, my lord. that was-
It's okay. Mr. Chaudhary, only two questions in your matter.
My lord.
First is that net and slet
Yes.
has been made compulsory by the UGC.
Right.
That is one. The second question is that insofar as the off-campus studies are concerned, there is already also a Supreme Court judgment on the point.
Yes, my lord.
So how both the issues can be overcome?
Oh,
in
only
your
thing
case?
perhaps, my lord, I am on a very slippery ground, I must admit. The only document perhaps your lordship may consider,
The similarly situated persons have been,
my lord,
similarly situated persons have been
Yes,
given
my
the benefit.
they have been given, and my lord, although the argument may be advanced that this is asking for negative equality, but at the same time, my lord, that also violates Article 14. They have been given, my lord. On some projects, on the, my lord, referring to some documents, some OM, that has been given. I have
You
not
see-
challenged their appointment, of course, my
No,
lord.
not that, they need not be challenged. Since you are taking the benefit of this parity.
Because my
And
lord,
that
there has to
is-
be reason as to why, my lord, we have been deprived while others have been given. You cannot pick and choose. That is the only, perhaps, my lord, the plausible ground on which your lordship may consider the case of the petitioner. They are working at a fixed pay of 8,000 rupees for so many years. These are cases of 2015.
Okay. Okay, I'll come back to you. I'll just take the answer on your query and then I'll come back to you.
My
Mr.
submission will be, my lord, that off campus, that is a, my lord, very, I'll say, my lord, that's a very loose term. And in fact, my lord, there are documents to show that off campus, my lord, those candidates who have obtained from off campus, they have been examined, they have been given. Right?
You see, let me tell you a few matters I have examined.
My lord.
In this acts by which these colleges or universities were opened, either under section 3 or section 4 of the act by which these universities were established,
My lord.
they have a clause regarding territorial jurisdiction. And in every such act we have examined,
That,
we found that
they-
the territorial jurisdiction is only the whatever is prescribed does not will not permit them to encroach into the territories of other states.
My lord, in fact, for that we will have to look into those materials are not here. Look into the, my lord, they have been deemed to be universities, and what are the conditions? Otherwise, my lord, open university, let us take the example of IGNOU. It's an open university, it can be done from anywhere, my lord. And that was the initial concept
No,
of,
you see, that is permissible, but to have an off-campus, that is what is being decided, has been decided by the Supreme Court.
Yes.
Off-campus cannot be operated. Within the
Yes.
territorial jurisdiction, they can offer what you call the courses. There's no difficulty in that. But when it comes to an off-campus, then only the Supreme Court has struck it down.
no, but they, my lord, if your lordship goes to the, my lord, various notifications that have been annexed, at different point of time, my lord, there have been different my lord, relaxations in respect of both, my lord, Nate and Slate, and in respect of the Open University. Now, my lord, if your lordship, Telegram could बोलना है? No. Telegram को चला दिया. Page 55 of the my lord, in WPC 7225, if your lordship kindly have a look at my lord, please.
Just 1 minute.
Page 40, page 21/3/2013.
Page 42.
Yes. It's 42 to legal assembly. It's 42. 42 legal.
This is it. This is that section 3 I referred to.
My lord.
Section 3, subsection 5 will say about the main campus at Wokha.
Yes, my lord.
Five proviso says it will be in the state of Nagaland. 6 says subject to UGC regulation allowing off campus.
Yes, my lord. In fact, I was about to going to submit on this. What is the, my lord, off-campus degree? One institution is in a particular state. I do not belong to that state. I take the course and appear in the examination going to that particular state. So although it is distance, but at the same time it is not off-campus because my lord, I go there and appear in the examination.
No, that has been decided by one of the cases saying that off campus would be place where admissions can be taken.
Yes.
Or classes could be, lessons could be imparted, or examinations could be held.
Yes.
These are the 3 criteria for that.
Yes, my lord, if I may read it, my lord, the main campus of the university shall be at Wokha in the state of Nagaland. The university shall have power to establish other campuses, study centers, etc. within the state of Nagaland for reasons of operational expediency, for broad basing of the activities of the university. The university may establish off-campus centers, offshore campuses, and study centers subject to provisions of UGC Act 1956 and the regulation made thereunder.
That does not permit, it appears from the Supreme Court judgment.
No, in fact, my lord, I think here, my submission, I don't think here. My submission will be, my lord, if your lordship kindly comes to page 42 of the, my lord, WBC 7225.
7225.
My lord, Tulika Das.
Yes.
Page 42. This is a communication from the government in the higher education department to the director of higher education. Page 42.
Yes.
Dated 2nd of June 2012. Sanction of creation of post for assistant professor working against in various provincial colleges of Assam. In inviting a reference on the subject cited above, I am directed to say that the government have ordered creation of 89 posts of to regularize the lecturers now called assistant professors who had been working without valid sanction posts, which posts are to be treated as personnel posts to the incumbents and listed in the department's concurrence letter conveyed by number circumstances dated 19/5/2012. Government have issued OM by number such and such dated 1/2/2012 to be effective from 1/2/2012, banning the off-campus in regard to obtaining MPhil degree only on 1/2/2012. But the incumbents whose regularization has been agreed as indicated above have obtained MPhil degree before the ban period and prior to the issuance of the OM dated 1/2/2012 from the off-campus from universities which are approved by the UGC. Government and Higher Education Department have now exempted them from the purview of the government the OM dated 1/2/2012 and their regulation made accordingly. However, this exemption will be effective only for the case of regulation of non-sanctioned lecturers only. For others, OM issued in this regard will be strictly followed with. Now, this OM, this communication has, my lord, given a cutoff date of 1/2/2012. And the petitioners fulfill that norm. And accordingly, my lord, the other persons, my lord, from page 45, these are only instances, my lord, 89 persons have been regularized. Page 45 to 49. And if your lordship reach any one of them, more particularly page 45, your lordship will find page 45, these are identical orders.
Yes.
On fulfillment of the terms and conditions mentioned in the office order number such and such dated 15/11/2002 in respect of Srimati Rajashree Bordole, lecturer in the Department of Botany, Dharan College, Post Office, Tezpur, so and so, regular UGC scale of pay of rupees 8,000 to 13,500 PM is allowed with effect from 10/3/2010 with the date of next increment on such and such date. Srimati Rajashree Bordole has obtained MPhil degree on 10/3/2010. The same way, my lord, the benefit has been given to many more people.
No, in fact, if I have understood their affidavit correctly, I don't know, reading singly, I don't know whether I've understood it right or wrong. But what I've understood from there is that they don't have any difficulty in adjusting you with your MPhil degree. What they are trying to say is that that would not amount to give you an exemption from net slet.
This is only exemption from net slate, my lord.
Pardon me?
This particular, my lord, notification which I just referred to, that is for exemption of, my lord, net and slate.
No, I don't know. That is what I understand from their affidavit.
Well,
For regularization, they don't have, they don't object to your degree. But only for the purpose of exemption, they are saying it is not. That is why what I have understood.
no, that is a little, my lord, self-contradictory submission, perhaps, my lord, if I have understood correctly. Because all these persons, my lord, they have obtained MPhil in 2010 or 2010. 4 persons, some persons have been picked up to give this benefit.
Because if you come to page 3 of their affidavit, higher education, I find that the clear stand is that petitioners will have to clear net slet. It has been made mandatory for lecturers who join after 24/12/1998. And in this para 5, para 6, page 6, they take a stand that the petitioners have been appointed after 24/12/98. The petitioners will have to clear net slet.
In the event your lordship accepts their submission, my lord, so their regularization or my lord appointment in the grant of that skill, that can only be, my lord, subject to their passing the next rate now. That is one way of, my lord, perhaps giving way to the plans.
Mr. Gogoi, can you get instructions if we allow them to be for their consideration? Can they be given further time to clear the net slet?
Lordship, we can even, Lordship, in one or two cases, Lordship, honorable courts extended the term from 2 years to 5 years, Lordship. Even from today onwards, Lordship may extend it. We have no objection. Even two cases, Lordship,
Mr. Chaudhary, can you have
Even I have
instructions?
also
If that
appeared-
is, if that is acceptable to you. Can you have instructions? We can
My
take
lord,
it up.
beggars,
even Honorable
Yeah,
Court also
which measures?
directed Lordship, not only Nathan's late Lordship, if petitioner can acquire PhD Lordship in the stipulated time period, then also Lordship, we have no objection. In one of the cases, Honorable Court, Lordship has already gone for that particular case, Lordship.
Yes, Mr. Chaudhary.
Lordship.
my lord, they don't have any other option. They already have their age gone, my lord. They cannot appear in any further.
No, but still, if you want to have, we can, you see, this is the part 2 list. We can take it up tomorrow, day after tomorrow, if you get instructions,
My lord.
so that,
Let him take the clear inspection.
so that it doesn't
And I
fall
do
on,
not have any objection, but I don't, option.
it doesn't fall on you.
Yes.
It will be their decision.
Even that condition, Lordship may dispose of today also. We have no objection
No,
because.
you see, senior counsel will not,
Lordship.
he'll have to take instructions from the instructor
Lordship,
counsel.
Lordship, 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 Lordship.
Since it's in the hearing list, we
Lordship,
don't have to
Lordship.
list it. We can
We have-
take it
we
up
have
day
no
after
problem.
tomorrow,
We have
day
no
after
problem.
tomorrow.
Any
Your
day,
lordship,
Lordship.
take up tomorrow, my lord, if there are no objection.
No, he is.
Our part, no objection. We have already in 2-3 of the cases, Lordship, already Honorable Courts, Lordship, extend the time period, Lordship. In Aurobindo Kumar Verma's case, as well as Lordship Nirmal Devnath case, as well as Deepika Das case, Lordship, Honorable Court extended the time, Lordship. We have no objection, Lordship. If petitioner may obtain instruction, Lordship, Lordship.
Because in this 2 issues, I've also dealt with few matters.
Already Lordship has disposed of 3 matters, Lordship, regarding that, Lordship.
My
Distance.
learned friend is submitting that there are other instances earlier, my lord, if that is their judgments can also be placed by him.
No, it can be done,
Yes, sir.
but there are many things, if there's a consent, then we can, I don't have to write so much.
Lordship.
Not that I would put it on you, everything, but the amount of what you call inputs which you have to, has to be given in on order can be shortened. Tomorrow, day after, whenever you
Tomorrow,
want.
my lord. Tomorrow, but day after tomorrow, in the second half, I have got difficulty. That's why, my lord, I am saying.
Okay, tomorrow then, no issue. It's in the part 2 list,
Lordship.
just ask someone to inform Mr. Gogoi and we'll take it up.
Lordship, Lordship. Acknowledgeable. Yes. As per Lordship's direction, I have received all the office memorandum, Lordship, since 2012 to Lordship. Last one is Lordship in 2022 for January, Lordship. In 2022 office memorandum, Lordship. Interaction with selection committee interview 3 marks is there, Lordship.
I'll just keep this. I will just keep this here so that whenever next it is required, we can get it from here.
Lordship may take this, I have already,
No, I mean, I'll have to keep it in the courtroom only.
Lordship may keep it.
So
Lordship.
that anytime it is required, we can take
Lordship,
it up.
Lordship. All the office memorandum since 2012, Lordship.
Now it is how much?
Lordship, last place, Lordship.
3 marks.
Lordship, Lordship, Lordship. Earlier it was 5 marks, Lordship, it was reduced to 3 marks, Lordship.
Earlier, it was 20%. That's why I have to look at Bennett.
Now it is 3 marks. 3 marks can be said to be unreasonable.
No, my only submission is if it is in conformity with the UGC regulation. Otherwise, it is not permissible any notification.
No, you see, for that, Mr. Prakash, sir, again, this office memorandum of 24 January has to be challenged.
Yes, yes.
The court-
If it is lordship in suppression of earlier notifications, then it is to be challenged.
It's
No,
cancellation
you
of-
see, we'll presume that they are right. Because of the fact that in this notification, it starts from the qualification for recruitment of assistant professor by referring to clause 3.0, 4.0, 4.4.1 of the UGC regulation.
Yes, sure.
And then they prescribe their mode. So even if we assume that 3 marks is not as per the UGC norms,
I shall have to
But three-
challenge this.
but 3 marks is inconsequential. It's not one which can weigh other considerations.
We can understand, Lordship, that the impugned letters have been withdrawn or struck.
It's deemed to have been overruled by the present one.
In this one.
So I don't have to write
Yes.
anything more in the order. Heard. Mr. SD prepares the learned counsel for the petitioner. And also heard Mr. K. Govard, learned standing counsel for the higher education department, preparing for all the.
Lordship, I am for 1, 2, and 3, Lordship.
No, 5 also.
5, Lordship is a provincialized school list, Lordship cannot lose.
You can't.
4, Lordship, someone.
Mr.
Someone, Mr.
1, 2, and 3
Lordship.
is presenting correspondent number 1, 2, 3. And Mr. A. Samuel, learned standing counsel for the UGC. And then bracket respondent number 4. None appears on call for respondent number 5. Next paragraph. By filing the writ petition under Article 226 of the Constitution of India, the petitioner has assailed the government memo number. Just right, the government memo dated. What's the number? AHE full stop 211/2015/104 dated 7/6/2016, as well as letter issued by the Director of Higher Education from Assam, wide memo number capital G within brackets capital B bracket close Miss MISC full stop 117/2015/22 dated 8/6/2016. Where is your that notification? Which page?
Page 25 and 26.
Huh?
25 and 26.
25 and 26. So you are challenging the abolition of marks.
Lordship.
Yes, sir.
Why?
That was abolished. Earlier, there was a 20% for interview. What happened, Lordship?
No,
I do not have PhD, but I am eligible to eligible for the post for participating in an interview. Once the interview is abolished, it is taken away. 20% scope of 20% marks gone. So
Okay. By which awarding of oral marks in the selection process for the post of assistant professor was abolished. Next, the case of the petitioner is that except for the PhD degree, the petitioner is otherwise qualified to be appointed as an assistant professor
economics.
in the provincialized colleges of Assam. It is projected that the petitioner has a MA degree in economics and also obtained MPhil degree from Periyar University, PERIYAR University in the year 2008, and has also cleared the state eligibility test within bracket SET for short, as well as national eligibility test within bracket NET for short. Full stop. The petitioner was appointed as teaching faculty in Golaghat Commerce College since 2/8/2010.
This is contractual.
Contractual teaching faculty. Full stop. The learning counsel for the petitioner has submitted that prior to the advertisement published in the newspapers on 28/5/2016, the selection process of assistant professor in provincialized colleges in Assam envisaged awards of 20 marks for interview. So it is submitted that as the petitioner does not have a PhD degree, he would suffer prejudice if 20 marks otherwise allocated for oral interview was taken away, because it would allow the persons having PhD degree an advantage over the petitioner.
In violation of UGC regulation.
It is submitted that the abolition of marks in the oral interview is contrary to the UGC guidelines.
Oh, Lordship, UGC regulation provides for 20% interview performance marks.
That's what I'm saying. Abolishing is contrary to the guidelines.
Lordship, I'm sorry.
Question. At next one. In the said context, the learned standing also to the higher education department has produced the office memorandum issued from time to time by the higher education department regarding selection of lecturer, public assistant professor in provincialized colleges in Assam. And it is submitted that the guidelines prevailing currently is in terms of the office memorandum number AHE / 239/2021/68 dated 24/1/2022, providing for the guidelines for selection of assistant professor, public librarians in provincialized government and government model colleges of Assam, whereby the government has adopted the eligibility qualification prescribed in the clause 3.0.0, 4.0.0, 4.4.0, 4.4.0, 4.4.1 of the UGC regulations dated 36/2010. And as per the said office memorandum, the marks for interaction with selection committee within bracket interview is now reduced to 3 marks. Full stop. Next, in view of the said submissions, the court finds that the court is of the considered opinion that the challenge made in this writ petition has become infructuous because of the fact that the memo dated 7/6/2016 and 8/6/2016, which have been challenged, is now replaced by the herein before referred to OM dated 24/1/2022. Next one, moreover, comments on a specific court query, the learned standing counsel for the Higher Education Department has submitted that the post for which advertisement was issued on 28/5/2016 in respect of Golaghat Commerce College has been already filled up. Under such circumstances, if the petitioner has an obligation to apply for any post of lecturer or the assistant professor, the petitioner would be now covered by the conditions imposed by OM dated 24/1/2022. Next, therefore, in view of the altered conditions which has been brought about by the OM dated 24/1/2022, it would naturally mean that the conditions contained in the memo dated 7/6/2016 and 8/6/2016, as held in this writ petition, to have been overridden by the OM dated 24/1/2022, which is now in force. Next one. Therefore, while holding that the challenge made in this petition has become infructuous, it is made clear that in the event the petitioner is still aggrieved by the OM dated 24/1/2022, he may be well advised to avail the remedy as may be available.
Because Lordship, I have annexed 2010 regulation. And they have said this new OM as per 2010. It is contrary to 2010 also.
No, maybe,
Now I have to challenge it.
maybe, but I'm not opining, right? But 3 marks would not make any dent because of the fact you see, now they have given 13 marks for PhD. So if you don't get 13 marks, even if it be what you call 3 or something, doesn't make a difference to you. According to this, reputation stands closed.
Although his instructions, the post has been filled up. I'm in economics. My instruction, it has not been filled up. I am continuing as contractual Lordship there.
No, they are not removing you. They have not removed you.
They have not filled up. It is not filled up also because this advertisement was never acted upon later on. So,
Okay, there you add that advertisement. It says that it isn't filled up. This fact is disputed by the learned counsel for the petitioner.
as it was stated by this court in this case.
I have forgotten that. This statement has been disputed by you. That's what I said.
Problems.
If it is also not fill up Lordship, at present Lordship, it should be fill up by the 2022 Lordship. OM
That's what I have said.
Lordship.
That's what I have.
Lordship. Oblige Lordship.
Obliged.
My lord may keep this bound.
Hey, higher education. Go ahead. Look at that.
Oblige.
Any other part 2 matters are ready for hearing? This is your item,
But I am for 78.
78. Who are the respondents?
What are the private respondents are appeared?
No, you have to.
I'm for the private respondent only, my lord.
Okay.
Oh, yeah, one BTC is there.
BTC is there, my lord.
CBTC.
Well, I have talked to BTC, my lord. One Ranjit Musare was entrusted with the case, my lord. He was out of station for today. So they inform us. We also inform them.
Okay. Let me take up some other day when both of you are there. You just come together, we'll take it up.
Obliged.
Okay. Yes. 61. Who is for the other side?
Hearing from the petitioner, my lord.
Who is for the other side?
Other side, my lord, the other, on 2 occasions I have informed them, my lord. The last 2 occasions. 2 private respondents are also there.
Mrs.
Respondent number 7 and 8.
You see, the difficulty is since I am jumping sequence. If anybody is watching the roster, you find it difficult to come to court. If both sides are there, we can come and take it up. Whenever you two agree, you come and take it up. Yes, Mr. Mahmood.
Our item is 70. We are ready.
No, is the respondents ready? Other side ready? You just find them.
Mr. 70.
No, there is a private respondents also 3 to 10.
Yes.
Private respondent.
You can ask them if they can come, we can take it up. Since I'm jumping sequence, I can't really take up the matter without notice to other side.
Any other day Lordship, I also try to inform Lordship. That's bad.
You should give them notice to other side and then. we'll take up the-
Both sides will inform the private respondent Lordship. Lordship.
Because in any event, in 10 minutes, I have to rise.
Lordship, Lordship,
There are two meetings.
Lordship.
Mr. Gogoi, can you meet me in the chamber after I rise?
Lordship, Lordship, Lordship. Lordship.
Hearing of the. I think the hearing not. That's all.